Good morning and welcome. I am so pleased that you've decided to join us this morning. I'm Lisa Ramirez, one of the founding partners of U.S. Immigration Law Group. Our firm is dedicated not only to providing exceptional legal services, but to educating, equipping, and empowering our community with valuable and important information as it pertains to U.S. immigration and nationality law. As you can imagine, the current climate is not a friendly one for immigrants in this country or those seeking to enter the U.S., whether temporarily or permanently. We are also very aware of the humanitarian crisis just outside our southern border. On a positive note, however, we've never seen more individuals concerned and in action to get involved and advocate for change. U.S. Immigration Law Group would like to be your partner in this endeavor. So whether you have a personal matter you are seeking to resolve, or you serve a broader community in your area or your family, please know that we are here to help and support you. To this end, our firm will be hosting monthly webinars in 2020 on a variety of topics throughout the year. This first one, we thought to kick off the new year, we would update you on some important and significant changes and developments as it pertains to immigration law. So you have a better understanding of what's happening and how you can best prepare and prepare those you serve. If you would like to stay informed about upcoming webinars, please visit our website and join our email list. And if there are topics that you would like us to cover, please do not hesitate to email us at info@usilg.net. And you are also welcomed at any point during the session to go ahead. There is a toolbar that you have available that you can ask any question that may be relevant to our topic today, or you can post a question that maybe we did not cover and you would like to see addressed. And I'll do my best to get through all of those questions either during the presentation or at the very end. Okay, so without further ado, I would like to go ahead and get started and share with you some important changes with regards to immigration law. All right, so to kind of give you a context in terms of where things stand right now in generally, I'm sure you're all aware that enforcement efforts are up, and they're up across the board, meaning everything from employment and I-9 audits and investigation to apprehension of undocumented immigrants has significantly increased, certainly during the beginning of this administration, and it continues to increase each and every year. To give you some kind of idea, and you can go to the CBP, the Customs and Border Protection website, which is part of the Department of Homeland Security, if you want to read more about it. But basically, more immigrants are being apprehended than ever before. If you compare the numbers from the fiscal year of 2018 and the fiscal year of 2019, which ended in October of last year, apprehensions have increased by 88.5%. And so that is talking about the individuals who have been stopped at our borders, who are seeking humanitarian relief or asylum, anybody who has been essentially apprehended. We also are very much aware that there's a significant number. In fact, we estimate about 57,000 migrants that continue to remain at our borders under the Remain in Mexico plan that are seeking asylum. So those individuals are not captured in the apprehension numbers as they are currently outside the United States and in their legal proceeding. We also know that 61% of immigrants placed in removal proceedings have been detained under the Trump administration. And we're going to talk very specifically about the impact of criminal convictions and the increase of detention. Because although deportation numbers themselves have also increased, what's been so significant is that just the number of individuals who have been incarcerated, not for criminal convictions, but again, because of their immigration status. And so that compares to 27% of individuals that were kept in detention under the Obama administration. And you can look at the track data from Syracuse University if you'd like to read more about that. We also know that those that are proceeding on some legal basis for a benefit, and that could be anything from a humanitarian benefit, it can be a family-based petition, employment-based petition, we're reaching crisis level of delays in those processing times. And that is pretty much across the board. We'll also mention in a little bit about what the government perceives as a fix to these processing delays, as they're going to be increasing their fees. At least they're proposing to increase their fees quite significantly. And their promise or their purpose in increasing those fees is to try to get these processing delays reduced. However, those of us that practice in this area know that the processing delays are not merely caused by the sheer number of applications or the increase in applications that the government is receiving, but really a big contributor to the processing delay is the significant changes in policies that have taken place that are requiring more work and more time of adjudicators to handle and process basic petitions. We also are aware that temporary protected status, some of you may be familiar with that, it's a humanitarian relief for individuals whose home country has experienced some sort of natural disaster or civil unrest, that they have exactly that, temporary protected status. They cannot be removed or deported from the United States. They have work authorization. There have been individuals from certain countries that have had this protection for decades, and the administration has essentially terminated that program. And again, we'll talk a bit more about that in a moment. I already mentioned the Remain in Mexico plan for the asylum seekers. Approximately since the program was implemented almost a year ago, there have been 57,000 people basically kept just outside of our borders who are seeking asylum and protection here in the United States. We're also familiar of the current zero tolerance policy that resulted in family separation, which continues to keep children separated from their families. I believe that there are still 57 minors that are in government custody that have not been able to be reunited with their family as a result of this policy. And then the last thing that I just kind of want to mention for purposes of context and where we are today is it dawned on me probably, I don't know, maybe about 6 months ago or so, or 9 months ago, that, when I first began practicing immigration law, I would go and I'd speak at different, colleges and high schools and schools, and realizing at the time, this is well before DACA even existed, that there was an entire generation of young people who taxpayers had paid to educate and go through our education system, who were graduating at the top of their class, that had, been told to study hard, and they would be able to pursue a career or a good paying job. And at the end of the day, what they really learned and discovered was, after all of those years of education and hard work, because they were not legalized, they did not have a social security number, they would not be able to work. They would not be able to enter the military. They would not be able to seek opportunities of higher education and have access to the same type of financial assistance that other individuals, whether lawful permanent residents or U.S. citizens, would have. And DACA was a great opportunity. I think it wasn't a perfect fix, but we're now at a place where this incoming freshman class for colleges and universities are really facing that same pre-DACA reality. They were too young at the time that DACA was terminated in terms of new applications not being accepted, so they could not get that same deferred action and the protection from deportation and work authorization. So we're now again seeing this group of individuals, these young people, eager to contribute to our society, and they're not in a position to do that really effectively. So that's kind of a part of our current climate and reality as it pertains to immigration. So I want to we have a lot of topics to cover today, and I wish I could do them all justice and go through them in depth. If there is a particular subject that you felt we touched on and you really want us to go more in depth about, feel free to let me know through the question portal, and I'll take a look at that, and I'll try to expand when I'm able to, or we can consider doing a webinar just on that topic. But something that I think is very important for especially those of you who live in Southern California is that I don't think there was a lot of publicity around this significant change, but the USCIS, the Department of Homeland Security, essentially redistrict their local offices. And so what that means is San Bernardino, Santa Ana, we used to be part of the Los Angeles District 23. However, because of restructuring and reorganization, San Bernardino and Santa Ana are now, and I should say Orange County, it's not the cities I'm talking about. So the County of Orange, the County of San Bernardino, and Riverside are now part of the San Diego District. So we get a lot of people, calling or inquiring, concerned because they're now seeing their interviews, whether for naturalization or adjustment of status, appointments being scheduled in San Diego. And there's a great deal of stress and concern around this change because those of you who are from Southern California are aware that there is a checkpoint just south of San Clemente. So to drive through that checkpoint kind of makes a lot of people very nervous, especially if they don't have legal status and maybe the purpose of their interview is to try and obtain that legal status. We want to make sure that everyone is kind of rest assured. Obviously, there's no protections granted until protections have been given. But if you do have a pending case and you are traveling for purposes of the interview, you should have those notices in hand so that if you do get subject to the stop at that checkpoint, you can certainly demonstrate that you have an application pending with USCIS. And I know that there's people, even lawful permanent residents, that are very nervous about making that trip. And I just want to explain kind of what's happening organizationally with the government that would cause people to have to go down there. Also, people have been asking and inquiring in terms of accessing the local offices. And I think I've mentioned this previously on a past webinar, but it is not possible to simply visit a USCIS office any longer or to easily schedule an InfoPass appointment as we used to be able to do like you would do for the DMV. Any communication essentially, if you're looking to find out the status of your case or you're having an issue or you have an emergency, has to be done through the 800 number. The government is also encouraging individuals to set up a My USCIS account if you do have any application pending, and there is a mechanism through that portal through which inquiries can be made. But definitely it's become more difficult to get responses from the government on changes or status inquiries on pending applications. So those are kind of some just updates about the organization and redistricting of USCIS. I mentioned this briefly, but I think it's something very important that the government has published in the Federal Register their intention of increasing the fees. Now, they had initial comment period, and I believe they received somewhere upwards of 10,000 comments and concerns related to these fee increases. The fee increases are significant in some areas. Across the board, there are some that do not experience a lot of fee increases. There's some applications that may either see no change or maybe a slight decrease. But the ones that I kind of want to bring to their attention, because I think that they're the applications that are most common for our community to submit, is the application for naturalization. It's going to increase by over 80%. So if you see, the current fee right now is $640, which doesn't include the biometrics fee of $725. So those of you who are aware and working in this area, the application fee is $725 when you add in that $85 biometric fees. Well, the proposed fee, again, not including the biometrics, is going to increase to $1,170. It is going to be very expensive and perhaps out of reach for our low-income community who are eligible for naturalization but may not be able to afford that fee. It's going to be very difficult and expensive, essentially, to apply for naturalization or U.S. citizenship. The other significant change that's part of this proposal is the proposal is seeking to eliminate fee waivers. What does that mean? That means that there's some applications that the government has available where an individual can complete another application form. It's an I-912. Essentially demonstrating economic hardship, or if they are receiving public assistance, that they do not have the assets or the income or the means to pay the application fees. That is included in a lot of humanitarian type applications. We can be talking about like U visa, also for naturalization, those who need to renew their green card. Those are just some examples where fee waivers are common. So if fee waivers are eliminated, it essentially means that it's going to create a hardship for those that fall below the federal poverty guideline to be able to afford that application or to seek any benefits that that application may provide. There is currently, the U.S. government, essentially, there was a comment period that closed at the end of December. Well, they just recently reopened it last week. So there is now a new 15-day public comment period, and I just would encourage all of you, and especially those who may not be accustomed to communicating or providing input. It's really easy and simple to be able to comment on the proposed rule changes and increase of fees. Just voice your opinion. What impact would that have on you? What impact would have on your family or those that you may serve, and why do you think it's a good idea for the government to reconsider? Now, one of the things that the government is indicating that these fee increases are necessary is, again, going back to what I mentioned earlier about the processing delays. They are essentially saying that if they increase the fees, then they'll be able to hire or purchase additional resources that will allow them to process applications more efficiently. However, again, the government does not recognize in terms of the additional burdens and costs that have been created by their own policies. And so that's a huge contributor in terms of some of these processing delays that individuals are currently experiencing. So I share that information with you. We don't know exactly when the rule, whatever changes will be finalized, will be announced. We'll definitely keep you posted. If you're on our email list, you'll get that information immediately. But we're really encouraging people to apply for these benefits, especially citizenship, sooner than later, because once that fee increase goes into effect, and if they remove the fee waiver for those who fall below the federal poverty guideline, then essentially some of these benefits may be out of reach. So please, please, please don't hesitate and pursue those benefits sooner than later. Okay, I just want to mention briefly, I'm sure this is on everyone's kind of mind and radar, but I think it's important to simply mention, we get people who are really concerned about whether or not they need the REAL ID, you know, what's required, what's it used for. So essentially starting August 1st of this year, the REAL ID is going to be required as a form of identification to access federal facilities, enter nuclear power plants, and to board federally regulated commercial aircraft. So I think the most common need or necessity that people would want to have the REAL ID for is for travel, for airline travel. So you don't need the REAL ID, but you would need then a passport if you don't have the REAL ID to be able to travel by aircraft after October 1st, 2020. So again, people think that they have to have it. There may be issues or problems with their ability to obtain it. It's created some anxiety for some folks that, yes, it will be required effective October 1st of this year, but there are alternative identifications such as a passport, whether it's a U.S. passport or a foreign passport that meets the REAL ID requirements that can be used in lieu of this ID. All right, I want to spend a little bit of time on the impact of criminal convictions because there have been some pretty major and significant changes with regards to um, the impact of criminal convictions on immigration applications and benefits. So first off, I just want to start by mentioning a couple of cases that really impact immigration court proceedings, but more specifically, the detention and apprehension of immigrants. And I guess I just want to start off by saying if you or anyone you know has any kind of criminal conviction, even if they think that the criminal conviction has been expunged, it is imperative that they speak to an immigration attorney as soon as possible prior to seeking any benefit. And I will tell you why. Because there's a tremendous amount of misunderstanding about criminal convictions, the severity of criminal convictions, the sentencing of criminal convictions, and post-conviction relief that may be sought in terms of whether or not an individual qualifies for a certain relief. So, for example, generally speaking, there are criminal convictions in a particular state. I'm going to use the state of California as an example that may be classified as misdemeanors. And people sometimes think that those are not significant crimes because they're just misdemeanors, they're not felonies. Well, there are some misdemeanors classified by state law that may be considered aggravated felonies under U.S. immigration and nationality law. So just because you have one definition under state law, there's a separate definition under federal immigration law. And so when you're applying for any benefit, the federal government is going to use their interpretation of that penal code, not the state's interpretation. They also have their own rules in terms of when any type of post-conviction relief is sought, whether it is valid for immigration purposes or not. So we get people coming to their office saying, no, they don't have any criminal convictions because they got them expunged. Expungements, generally speaking, do not matter for immigration purposes. The federal government can see right through them. So probably a very common example that people perhaps don't understand the severity are DUIs. So there are individuals that may be convicted of driving under the influence. In the state of California, for example, perhaps it was just a misdemeanor, and they're shocked to find out that they basically can be a basis for the federal government to deny them naturalization, lawful permanent residency. It could bar an individual, depending on the severity, from relief in immigration court. They are very, very serious. In fact, I had a prosecutor, a trial attorney in one of our clients' cases that had 2 DUIs in his criminal history that essentially accused my client of attempted murder. That is how serious the federal government looks at DUIs. They are very serious offenses under immigration law, despite the fact that they may not be perceived as severe under our state laws. On December 10th of last year, USCIS expanded the guidance as it relates to naturalization requirements for good moral character. So those of you that are familiar with this work or may have, read enough about applying for naturalization, have tried to or are aware of the good moral character requirement, there have been some significant changes where USCIS issued separate policy guidance in their manual about how 2 or more convictions for driving under the influence or post-sentencing changes to criminal sentencing might affect good moral character determinations. So under the Immigration and Nationality Act, which is our federal law, an applicant's required to establish good moral character. And although the Act does not directly define good moral character, it does describe certain acts that bar establishing good moral character of any applicant. So there's some examples that are laid out in terms of the specific types of crimes, but now we're seeing that the government is really becoming more stringent in terms of how criminal convictions impact good moral character. So be very careful. I want to warn especially nonprofit community organizations or well-intentioned individuals, notaries, immigration consultants that are very eager to help people become U.S. citizens. I think it's a wonderful contribution and a wonderful effort being made. However, if you end up submitting an application for someone that has criminal convictions and you haven't, kind of evaluated the significance of those convictions, it could result not just merely in the denial of their naturalization application, but also the revocation of their lawful permanent residency. So it's really important that you handle those cases, or perhaps not handle those cases and refer them out, but handle them very carefully with the utmost sensitivity. I have had 2 clients recently, and most of our removal cases, I should mention, before I share those 2 stories, have been results of people being denied naturalization and they're placed in deportation or removal proceedings. They're not coming from, people who are being apprehended because of their criminal convictions. These are people that either had past history many years ago that didn't understand the consequences of those convictions and should not have applied for naturalization at all. So you just want to be very careful. We've had 2 people, in fact, one of them apprehended at their naturalization interview for some criminal history and placed in detention. And then another individual who had applied for their permanent residency, they were not apprehended at their interview, but their adjustment application was denied as a result of their criminal history because, in fact, this case, it was an inexperienced attorney failed to understand the immigration consequences of those criminal convictions. And what happened is that he was later apprehended at his home. He is currently detained in Adelanto. And one of the things that I'll mention now is that previously individuals who were not transported from criminal custody to immigration custody immediately could apply or qualify for bond. Because of the Supreme Court decision last year, the government now has the legal right to detain those individuals and subject to what we call mandatory detention, meaning that they're not eligible for bond, that they have to remain in custody for the duration of their immigration proceedings. So in this last case that I just mentioned, the client had some drug-related offenses more than 15 years ago. And it was a result of the denial of his adjustment that he was apprehended, and now he is subject to mandatory detention, that he is not eligible for detention. The other important change that I would like to mention with regards to criminal convictions is previously, there was a lot of things that criminal defense attorneys could do after a conviction has been finalized to avoid the immigration consequences. We call that post-conviction relief. I'm not talking about expungements, but there's things like the Prop 47 that had passed that would allow an individual to have their charge either modified, the sentencing modified, some outcome change with the underlying criminal convictions to avoid the immigration consequences. Well, interestingly enough, the Attorney General of this administration back in October of last year essentially took on 2 cases. For those of you who are interested, it's the matter of Thomas and the matter of Thompson. And basically what he did in those 2 cases is indicate that anybody who has had post-conviction relief obtained for immigration purposes, or if the government ascertains that it was done to avoid immigration consequences, that post-conviction relief would be deemed invalid. Okay, so essentially the federal government is saying it doesn't care what happened in the state court. It doesn't care on whatever basis that the judge decided to modify a sentence or modify a charge or reduce the charge. The federal government has the right to determine whether or not that activity was done for purposes of avoiding the immigration consequences. And if the federal government determines that the modifications took place to avoid immigration consequences, then they could essentially look right through it and still hold the person to account for the initial conviction or the underlying offense. Now, that includes vacatures, so people who have had their cases completely dismissed. And so now, because of this case, or these two cases, I should say, individuals that have any type of post-conviction relief sought have to establish that this was done on constitutional grounds. So either constitutional grounds that violated their due process, they had ineffective assistance of counsel, that they were not advised at the time of their plea of the immigration consequences. So that really has to be very clearly articulated and laid out in any type of post-conviction relief efforts. Because if it is not, and if there is any doubt, there is a strong likelihood, and not just our firm, but several immigration attorneys that I have spoken to are seeing a lot of challenges now with this new policy, this new rule, that even though it's clear to us that this was done on constitutional grounds, the judges and the government don't always see things the same way that we do. So we're filing more appeals for cases of this nature than ever before. So I know that that was a tremendous amount of information. I think it's an extremely important topic. It may be more information than you would have liked. And I just want to make sure that you're just aware. If you take nothing else from the information, I would just say be very careful and cautious when you're applying for any type of benefit and there's criminal convictions. Okay. All right. I'm just looking at a couple of questions I just want to answer really quick. So people are asking about the specific requirements for the REAL ID and if they're requiring it now. So no, they can't require it before October 1st, 2020. So as long as you have it before then you should be okay. If you want to know the specifics, you need to be able to provide like the originals of your birth certificate. The DMV has your local DMV, so whatever, if you're in the state of California, you would look at the California DMV, but whatever the equivalent of your Department of Motor Vehicles, they would have laid out very clearly in terms of what the specific requirements are. I don't have time to read those or go through them right now. People are asking about traffic convictions, if that should be something to be concerned about, things like negligent driving. So I want to make a distinction between convictions in terms of like felonies and misdemeanors and infractions. So when we're talking about traffic citations, perhaps things like negligent driving, and I have to be very careful because there are some vehicle codes that one might interpret as negligent driving, and it's really reckless driving, which has very different consequences. So if the conviction is an infraction, it typically does not hurt or have the immigration consequence. But I will tell you, probably 7 out of 10 times, we have people misconstrue their convictions. So that's why here at our office, we would never take anyone's word for their criminal conviction. We rely on documentation, whether it's court records or California Department of Justice criminal history records, but we have to look at the facts because I think people don't always understand what their conviction was for. So I'd say just make sure that you're clear. Again, if it's for an infraction, things like speeding tickets, missing a red light or something like that, it's likely not to have an immigration consequence, but you can't ever be too sure. It's always best to get a legal opinion on the topic. All right, I'll have to wait to answer that offline. Okay, so one of the questions, and I'm going to hold this question off to the very end, but the question is, what can colleges and universities do to assist students who are affected under the current federal policy? I think it's a great question, and I have some great ideas, but I'll leave that for the end. So, okay, let me go ahead and continue. So one thing I also want to talk about, very hot topic. It was all over the news. Some of you probably have heard about it. So there was an injunction in place. Let me back up a second and provide some context for this conversation regarding the public charge rule. So one thing I want to make very clear, that public charge is not a new law. I believe the law has existed and been in place since the 1800s. Essentially indicates that the U.S. government has the right to determine whether an individual is going to become dependent or a burden on the federal government should they be allowed to be given legal status or permanent residency here in the United States. This public charge rule has been in existence, like I said, probably for more than 100 years. What's significant about this new policy is the interpretation of the public charge rule. So previously, there were issues and concerns if anyone had evidence that or if the government had evidence of an individual being dependent on public benefits, for example, they could trigger the public law rule. Now, what the government has indicated is that they have established new criteria for what is going to be taken into consideration to ascertain whether an individual will be or is perceived to be a public charge. So things that the government is going to be looking at is things like a person's age. Are they of working age? If they're under 18, if they're over 61, it's going to be considered a negative factor for them. They're going to look at their English proficiency, saying, the presumption is if you don't speak English fluently, you're less likely to be able to support yourself and find a job, which those of us who work with the community in any other language know that there are plenty of people who do not speak English fluently and still have no problem supporting themselves and employing themselves. Another factor is going to be their medical history and medical conditions. So does the person have health insurance? If the person has any licensing or their education. So all of these factors are going to be evaluated, and if the person cannot demonstrate to the satisfaction of the government that they have sufficient positive factors, the government can deem them to be a public charge. And that is a huge problem for a variety of reasons, and one and most importantly is that there's no waiver for the public charge inadmissibility ground. So if the individual has been deemed to be a public charge, their application will be denied. If they're here in the United States, they will be sent to removal proceedings, so their case will be filed with the immigration court to try to remove them from the United States. If they're outside the United States, then their visa application will be denied and they will not be able to enter the United States. Now, I want to be very, 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 very clear. This has no impact on individuals applying for U.S. citizenship, okay? If an individual is already a lawful permanent resident and wants to apply for citizenship, they do not need to worry about the public charge rule. The public charge rule only impacts individuals who are seeking admission to the United States. That could be in the form of a permanent status, like lawful permanent residency, or it could be in the form of a non-immigrant status, things like an employment-based visa, a tourist visa, a student visa, things of that nature. So anyone who's seeking admission to the United States is going to be evaluated for public charge. Now, this rule was supposed to go into effect October 14th of last year. At the 11th hour, there were federal injunctions put in place. I believe there's a total of 9 lawsuits, if I'm not mistaken, at very different places throughout the country. So the issue basically went up to the Supreme Court. However, because of the injunction, the rule was prevented from going forward here in the United States. Now, we already know that the rule did continue to go forward outside the United States, meaning that the State Department that oversees all of the consulates and embassies outside the United States has already implemented this rule. So we've already begun to see how this rule impacts individuals in their visa application processes. And it's not great. We've had clients that have come to us after their visa interview having been denied because they couldn't show that they were going to be able to get health insurance. They've been denied because of a medical condition. They've been denied because they don't have a job offer already here in the United States. So as a practitioner, we have been extremely cautious and super proactive to prepare our clients when they're subject to consular interviews to have these bases covered to the best of their ability. So whether that means that we include, certificates and diplomas of their education, if they're fluent in the English language, then we try to document that as well. If there are job offers that they can get, we send them with job offer letters. If they're eligible for health insurance or they have a promise or commitment to have that provided by their spouse or by their employer, then we make sure that they're armed with all of that evidence and documentation. So we're already seeing the effect of this. So now what happened this week is that the Supreme Court essentially removed the injunction, which essentially means that effective Monday, this new public charge rule, as proposed, can be implemented. And so one of the questions that have kind of been circulating already, if people want to know, does this go into effect immediately? So legally, I say yes. There's no injunction in place. There's nothing that prevents the government from kind of implementing this new rule. Now, as a practical matter, however, I will say I was at USCIS office, in fact, yesterday for a client, and I was talking with one of the adjudicators trying to get her sense and feel for it, and they clearly have not gotten any guidance or direction or training on the topic as of yet. So as a practical matter, I don't believe that this is going to be immediate, like this week, but we know that this administration is going to be fast acting because they were fast acting back in October, laying out new forms without much notice. Literally within 24 hours, they posted new forms to capture some of the questions that they want to ask that pertains to public charge. So we do anticipate additional guidance, instructions, direction, forms to be changed with regards to public charge. But here at our office, we are proceeding cautiously and we are preparing clients. We're actually re-preparing clients because we have clients that have interviews this week and next week. And we're now going back and making sure that they understand that this is now a legal reality. And if any questions that are asked along these lines, that they're prepared on how to answer. So again, we want to be as prepared and proactive as possible in equipping and educating and empowering our clients, our community on this topic. So we have a really great handout that is available under the handouts tab. So we've got, I believe, 5 handouts made available to you as a part of this webinar. One of them is the public charge. We put a lot of effort to summarize the rule in a very simple manner to make it accessible and understandable to our community. So please feel free to share it, distribute it, disseminate it. We also will have it. I don't believe it's posted on our website yet because we needed to make the implementation rule. We needed to update that, but that should go live probably sometime later today. But the handout has been updated. That's available through this webinar with that effective date. But it really outlines in terms of who can be impacted and what types of benefits. So again, we're talking about the food stamps, welfare, Section 8 vouchers, and housing. So we really encourage families to consult with an immigration law expert to evaluate if they may be deemed a public charge if they're receiving any of those benefits. Now, there are exceptions. Again, the handout outlines those exceptions. People who are seeking, benefits on humanitarian grounds, whether it's asylum, U visa, VAWA, SIGIS, and also if it's for, children, U.S. citizen children, that will not apply. So we want to be very careful, and we have to really look at, especially when it comes to any type of public assistance that people may be receiving because of medical conditions. There are some funding sources that may be completely permissible and not applicable to the public charge rule, but part of our job is to ascertain that source of funding. So whether we've got Ryan White funds, if there are any federal funds, and it sometimes comes down to the case manager having to look at the specific code of those funding sources to determine whether federal funds are involved, that the person has to, explicitly disclose that they've received these benefits and if it will impact their eligibility for benefits. So very hot topic. Again, if you have questions, Feel free to, refer clients to us, consider us a resource. We do our best job to do community education presentations and help people understand and prepare for this rule as much as possible. All right. I kind of covered some of these. I'm sorry, I just realized I had a tab about that. If you're a lawful permanent resident, you got a humanitarian, you have a green card already, you don't really need to worry about this rule too much. Again, unless you've got criminal convictions that have happened since you got your green card, it could be a problem. Or if you've traveled abroad and been absent for more than 6 months and you're trying to come back to the United States as a lawful permanent resident, it could be a problem. So just be careful. I think there's a lot of anxiety, a lot of worry. I just want to be clear about who's impacted and who's not. And there's a lot of people who are worrying that don't need to worry about this rule. Okay, this information's on the handout, so you can go ahead and take a look at it. So I talked a little bit about detention already in terms of the apprehension, the mandatory detention, but I also kind of want to bring to light the detention conditions specifically. So here, those of you from Orange County are aware that there was a big push to close our local jails that were housing immigrants for the federal government. I was not an advocate or proponent of this happening because I was very aware of what the impact was going to be, and it's exactly what we've already seen. In that those of the detainees in Orange County, for the most part, have been relocated to Adelanto, which, without traffic is about an hour and a half from Orange County. So it's definitely pushed the immigrants further away from their families and loved ones. It's made visiting obviously more difficult. It's increased the distance and it's made it more difficult for attorneys to travel and for detainees to get legal representation. So we've got Otay Mesa, we've got Adelanto here locally as the two main detention facilities. But there was a big push in 2019 and a law that was passed that would essentially close private detention centers throughout the state of California. And I kind of understand the spirit behind it, and I am not a proponent, just to be clear, of detaining immigrants. I don't think it's necessary. I don't think it's humane. I think there are far other more effective measures in ensuring their participation and cooperation, whether they have legal proceedings pending or what have you, than having to incarcerate them. It is a big, big business and profitable business, I would say, for these private detention facilities. So I understand the spirit of wanting to eliminate the detention of immigrants. I'm behind that 100%. However, the impact of that is now immigrants are being sent further away. They're lucky if they're sent to Arizona. There are now 7 or 8 detention facilities that have opened in Louisiana, and so we're seeing that as the fastest growing detention facility. So imagine trying to represent an individual here, being here, but they are physically located in Louisiana. You can only imagine how difficult that may be. And what a lot of people, and especially the public, do not understand is that sometimes the courts are not present where the detainee is located. So taking the example of Louisiana, I had a client that was moved out to a facility in Louisiana, in Richwood specifically, a brand new detention facility as of July of last year. And no immigration attorney that I called that's a member of the American Immigration Lawyers Association could tell me the court that had jurisdiction over that facility. There was no physical court there. After many hours of research and calls, we later come to discover that the court that has jurisdiction of the facility in Louisiana is in Batavia, New York. So it just adds, again, to the complexity of representation, of due process, of immigrants asserting their rights, of applying for relief. It has just created a tremendous amount of obstacles and challenges. So I just share that with you. I wish I could probably do an entire webinar on this topic regarding conditions and the challenges and obstacles, but I just want people to be aware of the impact of these policies. And if they have an individual who is apprehended or detained, do not be surprised if they are taken not just to Adelanto, but out of state. And the extra effort that goes through to find legal representation. I will briefly put a plug for the Orange County Justice Fund that exists here in Orange County. It's a 501c3 nonprofit, and basically their mission is to help raise money to post bond for immigrants in detention who qualify for bond and to coordinate legal representation. So they specifically focus on the detained population. I encourage you to check them out and consider donating, or if you have someone who is an Orange County resident that is detained anywhere in the United States, to please contact them, and we'll have their information posted and sent to you as a link at the end of the webinar. So, all right, DACA and the DREAM Act. I did an entire webinar on the DACA, the Supreme Court hearing that took place back in November. I encourage you to perhaps go to our website. You can listen to that webinar in great detail. This is going to just kind of give you a gist of where we are with DACA. Again, there's no initial applications being accepted. Current recipients can file renewal applications. We know for sure within 150 days, but because there's a lot of anxiety and nervousness about the decision that we're expecting to come out, literally it could be any day now, probably before June, when the Supreme Court goes on recess. People who have expiration dates outside of that 150-day period are taking the chance of renewing early, and we've had many successes with people doing that, meaning that they're not rejecting or denying those applications. It just cuts short whatever extension they may have. And again, the only benefit in doing that is to extend the DACA validity period on their work authorization should DACA be terminated completely by the Supreme Court or by the administration. So, and again, going back to the proposed fee increase, the fee is going to there's going to actually be a new fee which doesn't currently exist. There's a no application fee for the I-821D applications. So now it's going to be more costly for these young people and young adults to apply to renew their DACA, in addition to any application fees that's going to increase for their work authorization for the I-765. So again, there are some fixes that I want to talk about, but before I do, we'll talk about some potential outcomes just very briefly. Again, you can get a lot more information on the webinar that's posted on our website under the resource tab. So in terms of potential outcomes, the Supreme Court could basically determine on, how should I say, a legal basis that they don't have the authority, the legal authority to review the Trump administration's decision to terminate DACA, and therefore the injunctions that are currently in place are not valid. We're hearing a lot about injunctions. There's a lot of, and I know this administration is not very happy with these federal injunctions, but again, DACA, just like the public charge, has injunctions in place, but those would be deemed invalid. So that's one possible option, right, that could happen. The court could also conclude that, yes, it has the legal authority to review the decision, and it decides that the termination of DACA by the Trump administration is lawful, which still then ends DACA. Or lastly, the court could conclude that, yes, it can review the decision legally and rules that the termination is unlawful. Okay, so what happens with one of those outcomes? So if DACA were to end for one reason or the other, like I said, under option 1 or option 2, then basically the administration is going to need to decide whether to continue to process the renewal applications that are currently pending. So if the decision came out today, for example, the administration is going to have to decide, what do we do with these applications that have already been perhaps feed in, that are currently, being adjudicated? Do we issue refunds, or do we continue to adjudicate them? And they're also going to have to decide as to whether or not they're going to allow the work permits to expire or to attempt a recall. So those DACA recipients, if the work permit is still valid for another year and a half, or say 2 years, are they going to just let them run their course and they can keep that work authorization until it expires? Or are they going to say, no, they're all going to be deemed invalid immediately, and they can try to recall those work permits, either having recipients send those back? And then we've got questions of fees and things of that nature, but we don't know basically what's in store. If the court concludes that DACA itself is unlawful, then we know for certain that There will be no new first-time DACA applications will be accepted. The government must stop accepting renewal applications immediately. And then again, we'll have to wait and see in terms of the court's reasoning in terms of the validity of the work authorization. And if I didn't include on there, but let's just suppose that the court deems that the termination is invalid, DACA should remain, then essentially it could take us back to 2017. New applications can be accepted, possibly advanced parole could come alive again. There's all sorts of possibilities, but again, we'll have to wait and see what the Supreme Court decides. Now, in terms of pending legislation, if any of you have been at any one of my forums, speaking engagements, this is kind of a big kind of point that I like to emphasize. DACA was never, how should I say, intended as a solution. And I don't think DACA is great. It's good, but it's not great. And I don't see that there's a lot of energy and organizing around pushing some pending legislation that really would have a significant impact for these dreamers or these DACA recipients. So these are the three pending pieces of legislation I just want to bring to your attention and really encourage you to get active on and communicating with our senators and our congressional representatives and pushing these pieces of legislation going forward. We have two DREAM Acts, one that's pending in the Senate, one that's pending in the House. And then we've got the American Dream and Promise Act that was initiated in the House, but is now current. It passed the House back in June of last year, and now it is pending in the Senate. We really need to see, this is what I'm going to say is probably the most palatable immigration reform that we're going to see anytime in the near future, even if we have a major change in the upcoming election, whether the president changes, Congress changes, but these are active pieces of legislation that can really have a huge impact for college students, for young adults, for those that are DACA recipients or those who perhaps want to be DACA recipients and are not eligible. So again, we have webinars on our website talking in greater detail about the specificities of these pieces of legislation that you can access on our website. I just want to make sure it's on our radar. Temporary protected status, I mentioned this as part of the current climate. So in 2019, it was announced that TPS is ending. Again, there were some legal battles and challenging not so much the termination of TPS, but the manner in which it was communicated and lack of notice. So we know for sure that they're going to be terminated. It was supposed to be terminated for people for Sudan, Nicaragua, Haiti, El Salvador, Nepal, and Honduras. It was supposed to end January 2nd of this year. Because of these legal battles, it's been extended for 1 year until January 4th, 2021. So you have there on the slides some of the expiration dates for the various countries. If you know of anyone that's subject to these expiration dates, they need to start planning now. Please, please, please don't wait for that expiration date to arrive and not have a plan. And that plan may include applying for adjustment of status. So people are not aware, and it's super important, and I say time is ticking, that TPS is considered an admission, that they may, if they've got, say, for example, U.S. citizen children that are 21 years of age, that could petition for them because even though they entered unlawfully, because they have TPS status, they may be eligible for adjustment of status. So anyone that you know with TPS, please have their case evaluated because there is a real opportunity available, and literally it's a little over 11 months now for some of these individuals to apply for legal status, and we want to see as many people as possible benefit